number 84, People v. Tramel, Cuencas.
Good afternoon. May it please the Court, Yvonne Shivers for Tramel, Cuencas. I'd like to reserve 2 minutes for rebuttal, please.
Yes, you may.
Thank you. The police who had probable cause to obtain a search warrant and faced no exigent circumstances violated Mr. Cuencas' constitutional right to counsel and to be free from unreasonable searches and seizures by coming to his home to make a warrantless arrest. The constitutional support for this position is found in the heightened protection that the Fourth Amendment accords the home, and also under New York State's Constitution, which gives individuals an indelible right to counsel that attaches upon the issuance of a search warrant. Now, there's a compelling justification for adopting a rule that finds it to be a constitutional violation of the right to counsel for police to come to the home intending to make a warrantless arrest when there are no exigent circumstances, even when there is consent. The consent in Harris, which was decided over 31 years ago, the court stressed the importance of protecting the constitutional right to counsel in New York when it intersects with the Fourth Amendment. And it specifically predicted that New York's right to counsel created an incentive for police to violate Payton by not obtaining an arrest warrant. Now, although consent was not the issue in Harris, since Harris, the consent exception has really been used in New York by law enforcement to undermine the constitutional protection of the indelible right to counsel. Police have an incentive.
Then why doesn't that rule extend to public places? If you're saying that the intention is to violate the right to counsel, does it really matter that it's the home? It could be outside, it could be...
It matters that it's the home, and we're talking here about limited ruling that applies to warrantless arrests in the home, because the Fourth Amendment has been applied to give heightened protection to the home, and crossing the threshold into the home to arrest someone without a warrant is a particular kind of violation. We're not asking for that to apply when an arrest is made elsewhere.
What's the connection exactly to the right to counsel?
The connection to the right to counsel is that when the police obtain an arrest warrant, the right to the indelible right to counsel attaches. Therefore, they're motivated, instead of getting an arrest warrant when they have probable cause and there are no exigent circumstances, they're motivated to simply go to the home, attempt to get consent to enter the home, and thereby avoid the attachment of the right to counsel that would happen if they went ahead and got a warrant.
But why don't those concerns, I understand your point, but why don't those concerns apply outside the home? I'm asking about what's the connection between the home and the particular concern about the right to counsel when the officer comes in on consent?
Well, again, the home has special protection under the Fourth Amendment, and this, there's an intersection, therefore, with two areas of the Constitution that have been held to have special protection: the home, and in New York, the indelible right to counsel. So that is why our argument is that this should apply to a warrantless arrest in the home.
If you go that far, though, do you have to overrule Garvin? Is that what you're arguing for?
I don't think you have to overrule Garvin, because Garvin didn't really depend on consent. It was a decision about crossing
coming
the
outside
threshold.
the house.
But to the
Right.
extent that you do have to overrule Garvin, if you find that you have to overrule Garvin, I think you have a compelling justification for doing so.
I mean, there were no exigent circumstances in Garvin either, right?
There were not. In Garvin, the question was simply whether or not the police could arrest the person on their threshold. However,
Could we go
Garvin-
back to Harris for a second?
Sure.
The way I read Harris is there was a patent violation, and then they took a statement, and the Supreme Court said you can look at attenuation. And we said no, because you can violate patent in that, and you really have no consequences then under our right to counsel. And I'm having a hard time seeing the connection between your argument and that justification for departing from the federal rule in Harris.
what I'm saying about Harris is that there was a very strong dicta in Harris in which the state constitution of New York and the right to counsel was discussed. And it was discussed in the sense of the ways in which the Fourth Amendment violations, particularly warrantless arrests in the home.
But you would have to create a new patent violation here. In Harris, there was an admitted patent violation.
I understand, Your Honor, but I'm not talking about what is presently considered a patent violation. What I'm talking about is consent.
What's presently not a patent violation is if you have consent. Right?
Exactly.
But you would change that rule.
Yes.
So that seems to me different from Harris, where we had an acknowledged patent violation, and the issue was a statement taken after that violation.
I don't disagree that it's different from Harris, but what I am saying is Harris sort of presaged that the existence of this particular unique rule in New York regarding the right to counsel and attaching, the right to counsel attaching when you get a search warrant sort of was a preview to what the police were likely to do if given the opportunity to get around that right.
But the
And-
incentive was to violate patent, openly violate patent, and then you'd still get a statement because you could show it was attenuated once you took them out of the home. Here, you'd have to create a new violation and then say you have an incentive after we create a new violation. So, there's no violation of patent if consent is valid. Put aside the consent valid or not issue, but if consent is valid, then there's no patent violation. So in Harris, they were concerned, we have a patent violation again, but you're getting around that by getting your statement in anyway on an attenuation basis.
Well, Harris did involve an actual patent violation, but I think that many of the concerns expressed in Harris about the Fourth Amendment, about warrantless arrests in the home, are applicable, and that rather than a patent violation, the consent exception has sort of become the way that police have contravened or gotten around the New York right to counsel. So for that reason, I think that if, to the extent that this rule would require the court to reconsider aspects of Garvin and other cases in terms of consent, that's what we're asking for. And there are compelling reasons for it. One is the notion that we want to protect New York's right to counsel, and we also want to make sure that people in the home are protected from warrantless arrest. Another is that the consent exception has proven to be troublesome.
What if they went to Gavin's house looking for consent to search for evidence, and they obtain that consent, and they go in, and then they see the defendant sitting there and arresting him? Is that good under your rule?
Well, if there are exigent circumstances,
No
they come...
exigency, consent to look for evidence.
Consent to look for evidence, and they see the defendant there and they arrest him on probable cause. If their reason for coming to the home is to arrest him without a warrant, then that's one scenario. If the reason for coming to home is not to arrest him without a warrant, then that's a different scenario.
So we have to look at the subjective intent of the police officer.
You know, I was about to get to that. You know, there was a concern in Garvin by the majority that, you know, we would have to look at the subjective intent of the police officer. But actually, there are objective criteria that would really be looked at in these situations. The first would be, did the police come there intending to arrest the person without a warrant? The second would be, did they have probable cause to arrest the person? That's a thing that can be objectively figured out. Were there exigent circumstances that justified not obtaining a warrant? Although we're sort of, technically subjectively looking at what the police officer's reason for being there was, it's very easily through objective criteria in most cases to figure out what the reasons were. And this case is actually a perfect example. Detective Fogelman and the Appellate Division found that the police went there with the intention of arresting him without a warrant. Detective Fogelman and his warrant squad, which is sort of an ironic name for them since they go without a warrant, but they went to the home with an open perp positive I-card issued based on previous identifications of the defendant a couple of days earlier, and had no other reason for being there. In fact, that's the purpose of the warrant squad, to go and make arrests. If you have those facts before you, you know that the police had probable cause, and there's, by his own testimony, he asked no questions, he simply did the arrest, and that was his entire participation in the case. You have objective criteria to figure out what the intention of the police were when they came to the house. That's just one example. I think that comes up quite often in these cases.
Would it just be probable cause to get an arrest warrant minimum? Because then you're saying to the police, well, that's the stage where you really need to get one, or it's close, maybe technically you have probable cause, but you want to do more. Then what's the rule? It would be good investigatory practice to do more rather than just arrest someone at the stage where we've developed probable cause to arrest. What happens next?
I'm not sure what you mean, do more.
So, you may have probable cause to get an arrest warrant, but there's an investigatory decision made that it's not a good time to get this. There's potential weaknesses in the case. We want to do more in this case before we get one. But then under your rule, you can't go to the house because you have enough to get a warrant.
If they're, right, that's an indication of their intention to make a warrantless arrest. I mean, if the
So
police...
it would, how would that not go on the subjective intent of the officer then? I've got enough, technically maybe, to get a warrant, and maybe if some magistrate reviewing that would say yes. I go to the house. Now, if I really am not intending to make an arrest, that's okay, but if
Well,
I
certainly,
am, it's not okay. How is that not subjective?
if I'm understanding you, these are criteria that the hearing court is going to consider in determining what the subjective intent is. So certainly the officer...
That is what you were saying we might not have to do, given our concern in Garvin about doing that? We don't have to look at subjective intent?
No, I'm not saying you don't have to look at subjective intent. What I'm trying to say is that many times the officer's intent can be determined from objective factors. An officer can testify at a hearing that he had some other reason for going to the house.
But
And that's something that can be
still
considered.
Subjective
But-
intent, and I don't see how that doesn't overrule Garvin, a case that's 6 years old, where we said a ruling turning on subjective and police intent is fundamentally inconsistent with the Fourth Amendment.
Well, to the extent that this goes to some of the concerns in Garvin, I would say that there are compelling reasons for nevertheless adopting this rule. The consent exception has proven to be troublesome in addition to the fact that it invites the police to sort of backdoor constitutional rights. It's been troublesome in particularly, you're getting into situations of, he said, in multifamily households, where I note that, where Amicus, Legal Aid Society, has noted that low-income New Yorkers and New Yorkers of color are more likely to live. It has proven troublesome in situations where English is not the first language of occupants of the premises. So the exception has proven not to be the greatest rule to apply. It's great for police who have found, according to studies, that when they testify at hearings, the hearing court is more likely to believe their version of the events. But It's also led to difficult situations in which lead to undermining the public's confidence in the police. Also, I believe, as I stated, a new ruler would be easier to apply because essentially of the objective criteria that I've mentioned earlier. So, in short, I believe that to ensure the desired effect of protecting the state constitutional right and also the heightened protection of the home under the Fourth Amendment, the court should hold that in absence of exigent circumstances, police who have probable cause and want to arrest someone in their home should get an arrest warrant.
Thank you.
Thank you.
Good afternoon. My name is Shalom Tversky. I represent the Respondent. Your Honors, I just want to briefly explain the flaws in the rule that the appellant is proposing. Number one, whether it overrules Garvin, but Garvin was a threshold case, so it simply rejects the reasoning of Garvin. Footnote 5 in Garvin says you can't consider subjective motivations. That's exactly what the rule is considering. Payton says there's a violation if there's a non-consensual entry into a home, not a threshold case, entry into the home. And it completely ignores the ability of a hearing court to make a determination whether there was a Payton violation regarding whether there was a knowing and voluntary consent to enter the home, which the people have a heavy burden to meet under the totality of circumstances. Plus, it assumes that the only purpose, if the task fugitive force, which was the squad that went out here, if they had probable cause to arrest, their only reason or their only motivation would be that the right to counsel not attach. There could be a lot of reasons. Garvin talks about simpler, faster, less burdensome. Now, those type of issues aren't necessarily dispositive, but they're factors in terms of whether you get a warrant or not. Also, the DAs would be concerned about the 30-30 clock starting to run when an accusatory instrument is filed. What happens if then the defendant flees? And then all of a sudden, there's going to be all that extra time running until they find him again.
Counsel, can I ask you to change gears for a minute and address consent?
Yes.
Can you tell me what exactly gave the police the belief that they had consent to enter from what Mr. Jeter did at the time?
Your Honor, first, in terms of that issue, so I have to begin by, on the train coming up here, I realized that there was a flaw in our statement of facts on page 6 of our brief. It's actually to our detriment, and the stars aligned because Ms. Shivers was actually on the same train. We exited the same door, and so as soon as I called my office, they agreed that there was a mistake. I immediately sat down with her. We looked at the transcript together, and we realized that it was a mistake, which I think is important to answer your question. So it's on page 6 of our brief. I would ask you to look at lines 10 through 13, and it has to do with which window the officers knocked on at the front of the house, which Jeter then came to, and then Jeter then seconds later opened the door. We had written someone then knocked on the ungated window that's next to the door, and if you look at exhibits 4A and 4B, this was in evidence at the suppression hearing. We had assumed it was talking about this window, when in fact it was this window. He said gated, 93, 94. That's the window that the police knocked on. That's the window he said Jeter then showed up on, and then he immediately opened the door. And we think it's a reasonable inference for the task force, Detective Fogelman, to have believed that this window was the apartment or the room that they saw on the ground floor when Jeter, after they said, "How you doing, sir? May we come in and talk to you?"
So that made them think it was Jeter's apartment. Is that what you're saying?
Or at least that Jeter lived there with defendant, the co-defendant, so therefore he at least had the apparent authority when he opened the door
Got it.
2 feet when they said, after knocking, 2 feet, "Sir, may we come in and talk to you, sir?" he opens it completely, this is according to the testimony, and then they enter this entranceway, which clearly, based on the photos, seem very small because they say the threshold to that door, which Jeter, now we can see, clearly came out of.
So that entryway is consent to enter the apartment that was entered? Is that what you're saying?
When the officers come in and Jeter has just not only opened the door, but stepped aside, and what do they say? They say right in front of them. I'm sorry?
Since you were concerned about the accuracy of the record.
Yes.
I believe the transcript, Detective Fogelman's testimony is that he opened the door a little bit wider. Not completely.
There's another time where he says completely.
Okay?
But to be clear, you're relying exclusively on the physical behavior when he opens the door and steps back, whether it's a little bit or completely. There's nothing else that you're relying on to show consent.
I'm relying on the fact that it was reasonable for them to think that Jeter came out of that apartment, and that when you have, now it'll be 4 officers plus Jeter, all standing in the vestibule where he's clearly impliedly consented
But
to have a
just-
conversation. Yes.
Just so I'm clear, with respect to Jeter's conduct.
Yes.
It's simply opening the door, and whether it was a little bit or completely, it's just that those physical acts.
And stepping back.
Yes,
And
okay.
stepping back, where after they had asked to have a conversation, the idea that the officers would have assumed, the conversation could only take place in this small vestibule when the front door is completely open. What I mean by the front door of the room downstairs
The
is
officer entered because Jeter entered the actual apartment where the defendant was located, because Jeter stepped to the side, or because he saw the defendant in the apartment?
I would say it's the totality of circumstances. It's both. He stepped aside. It's clearly a small entranceway area, and then he immediately can see.
So you keep emphasizing it's a small entryway. So if you have a small entryway, but it is not, there's a door to the outside, and there's a door to the actual apartment, are you saying that equals access to all?
When they clearly had a reasonable inference that Jeter had come out of that door and could easily have shut it before he opened the front door. That's a reasonable inference that he was allowing them to have this conversation that apparently he had agreed to.
How many doors are there? At the location, there's more than one apartment, correct?
Yes, there are,
And
but,
it is important to know what the officer knew as he approached.
right, and unfortunately, the record is not clear about that.
Whose fault is that? And whose burden was it to make a clear record as to what he knew when he entered?
Your Honor, perhaps the record should have been fleshed out more regarding whether this was his recollection 2 years later as to what the structure was after he had gotten in, or whether he knew that before. But regardless of that, based on them seeing Jeter come out of that room and then allowing them to enter, there's plenty of cases talking about
So everything
implicit.
is based on physicality.
I'm sorry?
Everything's based on physicality. So for some reason, the officer did not explicitly say, may we enter this apartment? Is this apartment yours? You don't dispute that there was no talking.
There also was no objection by
There
Jeter.
there was no talking. Everything is based on implicit, correct?
There is, correct. There is such a thing as implicit consent under the totality of circumstances.
So, counsel, it seems to me it might be different if this was obviously a one-family, building. But what does this mean for the many buildings that have more than one unit in them? Does that mean that anytime someone opens that front door, that is sufficient to infer consent to go anywhere?
Absolutely not. It's not just opening the front door. It's the fact that he clearly had come out of that room and had left the door open with the defendant sitting on the couch in open view. I'm not saying, therefore, because they saw the suspect, that all of a sudden, oh, good, he's here, that they were ready to, that they simply grabbed him for that reason. I'm saying that the scope of consent, and that's really what we're talking about here, is Jeter's apparent authority and scope of consent. They had a right because of the time.
The apparent authority comes from where?
The fact that he came out of that room, based
So
on at least a reasonable inference.
Your case got stronger on this train ride up to Albany today, because last time they just showed up, as far as they knew, he just showed up at the front door, maybe at the window that was next to the door, but they had reason to believe that he might have been coming out of that apartment. Now, if I understand you correctly, you're saying, no, they saw him at the window inside the apartment, which leads to, I guess, a greater degree of reliability to the assumption that he came out of that apartment.
That's exactly what I'm saying.
And was that clear to the suppression court?
So the suppression court, the prosecutor did argue that there's a reasonable inference that he came out of that room, but the suppression court didn't address that specifically. It just said there was tacit consent based under the totality of circumstances.
But I guess was the evidence in front of, to Judge Singus's question, was the evidence in front of the suppression court what you explained to us today, or was it what you explained to us last time?
That's the problem.
Everything I told you is in evidence was in evidence in front of the suppression court. I made the mistake of only figuring it out
But
3 hours
they
ago.
didn't argue in the suppression court the erroneous interpretation of that record.
I'm sorry, say that again?
They did,
Please.
the prosecutor didn't argue the erroneous interpretation of what was in the record.
The prosecutor, well, it gets complicated. The prosecutor did say that Jeter came out of this apartment, but the prosecutor had mistakenly said that the door to the stairwell had been closed, so that was a factor to be utilized.
My
That's the
question, though,
record.
is more specifically, did the suppression court know that the window that they knocked on was that gated window, and that's where Jeter came out of?
What I read to you is from the suppression court minutes, so that's what the hearing court heard. I can read you the 3 lines.
What's the page of the record, Counsel?
Let's see, of the defendant's appendix 93 through 95. Looking at 4A, which is this. Can you just describe, if it will help refresh your recollection, do you recall which window it was, meaning the window you knocked on? One of the front windows, right to the front door. Not the one with the gate? No, the one with the gate. And then the one with the gate, okay. And if you look at the trial record, and I know that's not supposed to be, it supports that, the credibility of that testimony from Detective
Does the
Fogelman.
record show that Mr. Cuencas...
I'm sorry, Your Honor?
Does the record show that Mr. Cuencas was in that room with a gated window?
Correct, it does, because as soon as they enter the entranceway, they immediately see right in front of them that door completely open of that area with defendants sitting on the couch in that apartment.
And is the picture that you showed us, where in the record is that?
Well, page 93, it just says, take a look at 4A.
So it's
And this is
Exhibit
4A.
referenced in,
Yeah, 4A and 4B, correct, because 4B is the interior this is the interior. And they say they saw this right in front of them. Your Honors, let me just briefly say, if this court would disagree, this court can find that the statements were attenuated as a matter of law. We're not suggesting that the photos in the cell phone, they would still be precluded. But the attenuation here, you have statements 8 hours, 11 hours, 16 hours. You have Miranda warnings being given twice. Even if you don't want to talk about the 8 or 11-hour statements, the 16-hour ones, that's on video from the ADA. Certainly that would be admissible. And even if you don't want to find it attenuated as a matter of law, you can remand it to the lower court to make that determination. Because the court didn't have to, because it found, as the appellate division affirmed, that there was no patent violation because there was, under the totality of circumstances, valid consent. And even if you don't agree with that, as I had argued last time, you could find that it's harmless error based on Winnie and Travis's unequivocal ID testimony that they saw the defendant and co-defendant kidnap Dudley with zip ties, making violent threats. Co-defendant is showing a gun, and then Dudley is found the next morning in a park with his throat and wrists slashed with bloody zip ties next to him. So therefore, you could still affirm this based on harmless error. If the court has no further questions, the people rely on our brief.
Thank you.
Okay, just to address the new interpretation of the
Yes,
evidence.
the revelation.
The revelation. First, I'd submit that it's really still not clear from the record that Fogelman understood. Fogelman wasn't the one who knocked on the window, and it's not clear that Fogelman understood that the gated window was the window to apartment 1. It's also not clear from the record that Fogelman knew that the person who answered the door was the person who looked out the gated window.
And again, it's incumbent upon the people to establish what he knew at that time.
What he knew at that time. And I would add that Jeter said he looked out the window next to the front door, which is the other window. So it's possible someone else looked out the gated window. It's not clear from the record.
What do you say
But
about consent?
in this case, what Fogelman knew was that this was a single structure that may have had 2 apartments, an upstairs and a downstairs. When he got inside, he said he was in a vestibule area, that's his words, and that once we entered the vestibule, we looked to the left, saw stairs going upstairs to the upstairs apartment, and in front of him, apartment 1, we'll call it, the door was open. So he knew there were 2 apartments. He called them apartments. There's certainly no suggestion he thought he was in a single-family house and looking into a living room. He called them apartments. This was Fogelman's understanding. So I don't think it necessarily decides the issue, even if Jeter came out of the apartment, because the question is the scope of the consent that Jeter gave. When Jeter opened the door to a police officer saying, "Can we come inside and speak to you?" there's no reason the police officer would necessarily have to believe that that meant, come on in this apartment and we'll speak. It meant, come into this vestibule and we'll speak. After that, things happened so quickly.
Would it be
Because-
inappropriate or error for the suppression court to reach the other conclusion that he meant, come on in, come into the apartment that I just walked out of, and we'll talk?
It would, because I don't think it's supported by the record. You know, he had them enter the vestibule. He made no further gestures indicating to enter the apartment, and things happened so quickly that I don't think the police even thought, oh, do I have extra
What about
consent
the
to enter the
emphasis-
apartment? They saw the appellant.
What about the emphasis of him stepping aside?
I guess he had to step aside. I mean, he's opening the door, they're coming in, and he steps aside. I don't think that
Well,
indicates...
counsel says it's really a small space, and he stepped aside, so it can be implied that it was consent to not only the vestibule, but the apartment that he apparently came out of.
Well, I'd submit that that's not really a reasonable interpretation of the scope of Jeter's consent. I think that...
How big is the vestibule?
Vestibule's pretty small, but you know,
When they, let's go with your suggestion that it's just the vestibule. Could they all fit in that vestibule?
I believe it's difficult to tell from the record. We know Detective Fogelman stepped in and that he was with 2 other detectives. What we don't know is, as soon as Fogelman came in, did he proceed into the apartment before the other 2 detectives were fully in the vestibule? It looks from the record as if all 3 got in the vestibule along with Jeter, but it's very difficult to say. But, you know, sometimes the area is small. In this court's decisions on things like in Garvin, such as stepping over a threshold, we're talking about a 2 or 3 inch space between doorposts. Here, yes, the vestibule is small, but I think scrutinizing the record, there's not support to find that the scope of Jeter's consent was to step over the threshold into the apartment.
Thank you.
Thank you.